Welcome back to Winning Isn't Easy. Let's talk about the 7 denial tools that carriers or plans use to justify a claim denial or termination and how courts have viewed these tools. In my experience, it's not uncommon for long-term disability carriers or plans to deny long COVID claims for the following reasons or a combination of reasons. Number 1, no proof of infection. Number 2, no diagnosis of long COVID. Number 3, no symptoms that are consistent with that long COVID, long hauler diagnosis. Number 4, you're not getting treatment that's reasonable and appropriate based on the severity of your claimed symptoms. Number 5, there's no functional restrictions and limitations that would prevent you from performing your own or any condition, which is known as your post-COVID functional status, or PCF. Now, number 6 is their argument that there's no connection between your diagnosis, your symptoms, your restrictions, and your alleged inability to perform your own or any occupation. And then one of the other common defenses I'm seeing is that your risk of exposure to people who might be infected with COVID or other medical conditions that could aggravate or accelerate your symptoms just isn't the equivalent of disability. So you may have gotten a claim denial or termination for one of these 7 reasons or a combination of the reasons. The question becomes, well, how can you go about attacking some of these bogus reasons? So let's take them one by one. 1, attacking the no proof of infection or diagnosis of long COVID denial tolls. Now, at the beginning of the COVID epidemic, carriers and plans were insisting that a disabled policyholder or plan beneficiary had to prove that they had a COVID infection. They would complain that you didn't have a positive COVID test or that one was performed by a physician or a medical facility. In other words, they didn't like home test results. Luckily, we don't see that argument much anymore based on, the false positive test results that even are present in tests performed by physicians or medical facilities. But, the widespread availability of home testing kits and the CDC guidance on the use of those kits, I think, has really overcome the disability carrier plan's argument that you couldn't possibly have all these symptoms because you didn't have a positive COVID test is gone by the wayside. How about attacking the no symptoms consistent with long COVID denial tool? Now, as the starting point for this particular defense, the disability carriers and ultimately courts are going to look closely at the policyholder or plan's beneficiaries' medical records. They're looking for symptoms of long COVID, an aggravation of a pre-existing medical condition by long COVID, or the development of new medical conditions caused or contributed to by long COVID. These symptoms should be outlined in your medical records, as I discussed in the first episode. So let me give you an example of how this defense unfolds. This is the 2022 case of Abrams versus Unum Life. And in that case, Abrams was a trial lawyer who ultimately was diagnosed with long COVID and chronic fatigue syndrome. Unum pulled out their denial toolbox and said, oh, wait a second, we're going to deny this claim because there's no formal diagnosis or a rule-out diagnosis. The symptoms are subjective in nature, and therefore any diagnosis is not objectively based, and his subjective symptoms didn't prevent him from performing his occupational duties as a trial lawyer. So what did the federal court end up doing with this? Well, the court said that Abrams did not have to have a compelling unifying diagnosis of the symptoms, or even the correct diagnosis. The court said that the lack of diagnosis or even the correct diagnosis was not the issue in the case. The issue was whether or not Abrams was disabled, as that term is defined in the policy or plan. Now, the court noted that Abrams had daily fevers, brain fog, diminished concentration, malaise, and a homebound status. The court contrasted his pre-disability life with his post-disability life. Abrams had trained and run marathons. He, like most lawyers, had worked 12, 14, 16-hour days on complex legal matters, and he wasn't able to do that anymore. And the court noted that the evidence that he submitted was objective in nature. What was that proof? Well, Abrams had daily fevers. So he actually submitted 23 video recordings on his phone with his temperature and a temperature log to document the relapsing fevers. So this was a really fantastic way of submitting objective evidence of subjective medical conditions. Now, I think that the key is a good interval history of your symptoms and functionality between visits to your doctor, keeping a journal, keeping a symptoms log, doing videos, having third-party statements. You want to really develop the basis for the doctor's opinion and restrictions and limitations. Well, how about that treatment? You're not getting reasonable or appropriate treatment denial tool. Obviously, you should be treating with a specialist who is, appropriate for the nature of your symptoms. Now, we're beginning to have COVID centers of excellence to treat the whole constellation of symptoms and complications, but in some areas they don't exist. And in some areas where they do exist, there's a heck of a long waiting line. So the disability carrier plan is going to expect that you're getting treatment by a specialist. So if you're having cardiological issues, they want you to see a cardiologist. If you're having lung issues, they want you to see a pulmonologist. So, obviously you want to get appropriate medical treatment by a medical provider and if possible, a specialty facility. What I will tell you is not acceptable is functional medicine or alternative medicine treatment. I'm sorry to say that, but the courts simply just don't accept that. And most disability carriers or plans don't consider that type of treatment to be reasonable or appropriate. Well, how about attacking the no functional restrictions and limitations that would prevent you from performing your own or any occupation denial tool? Now, obviously, you should be receiving testing to substantiate your long COVID symptoms and the complications. An example would be undergoing pulmonary function tests to document the nature of your pulmonary issues, or cardiological testing to document the cardiac complications. Now, they're also going to expect specialized testing to substantiate not only your long COVID symptoms and the diagnosis, but the impact of those symptoms on your inability to perform your own or any other occupation. So they're going to be looking for things like functional capacity evaluations, cardiopulmonary exercise testing, pulmonary function testing, EEG testing, neuropsychological testing, post-COVID functional status evaluation, a PCFS. Your records really need to be chock full of these testing modalities and results that will substantiate the basis of the restrictions and limitations. Well, how about attacking the no causal connection between the diagnosis, symptoms, restrictions, and your alleged inability to do your own occupation or any occupation? Again, I think the Abrams case is a good example because he was able to objectively document the nature of the symptoms. I will tell you that when we lawyers file disability insurance claims, I think we do sort of get the Kansas City advantage, if you will, because judges know what lawyers do. Judges don't always necessarily know what other occupations are, but they can see in their own mind what the occupational duties are of a trial lawyer. And they can say, look, if this person objectively has migraines, and here's the record, here's how often they have them, here's a video of them having a migraine, here is the remitting fevers, here's the log, here's this symptom, that symptom, and it's tied together by the physician with restrictions and limitations and objective testing like FCEs, and tied together with a vocational opinion, then it gets really hard, I think, for the court to reject the evidence that we're submitting. And that's because you're basically building layers on layers and layers of proof. And it's not speculation. So you can see that there is a rhythm and a pattern for developing this kind of evidence. Well, how about attacking the risk of exposure to COVID is not the equivalent of disability denial tool? Disability carriers like Unum really stick their nose up in the air at the possibility that a policyholder could contract COVID if they return to work. They routinely minimize the risks associated with contracting COVID as a basis for ERISA disability benefits. And this, in legal terms, is called the risk of exposure or the risk of infection or the risk of relapse defense. And that's exactly what happened in the case of Downs versus Unum. Now, Dr. Downs was a pediatrician who had practiced for over 40 years when she underwent gynecological surgery to remove her uterus and a precancerous growth. During her post-op recovery period, the COVID pandemic emerged, and she ultimately filed a claim for disability benefits based on the risk of contracting COVID. And at the time she filed her claim, she was 70 years old, had a history of cardiac heart disease, asthma, diabetes. And obviously, we all know she was at great risk for contracting COVID and potentially a higher death rate because of her age and her pre-morbid medical conditions. Obviously, she really couldn't practice medicine remotely because she had to examine infants and children who, in my experience, are little petri dishes of illness. So it really wasn't realistic for her to be in a clinical setting evaluating and treating children or being exposed to their relatives. Unum, of course, denied her claim for several reasons, saying that Downs's fear of contracting COVID could not possibly constitute a disability because then every health worker who was over age 65 would be deemed disabled if they made a claim for disability benefits, and that such fear could open the floodgates of disability insurance claims. So the court was faced with the issue of deciding if a person with a present condition that puts them at high risk of COVID-19, but would otherwise not prevent them from completing their usual and occupational duties, was disabled. And the court found in this case, based on the facts of the case, that the risk of future harm of contracting COVID did constitute a disability. The court noted that her occupation exposed her to COVID, that she couldn't perform her occupation remotely, and her age and underlying health conditions made it more likely that she could contract COVID and even possibly die. You can see that Unum took an extreme position in a highly sympathetic case and rightfully got slapped down. But again, the risk of exposure defense is one that we see commonly and needs to be attacked on a case-by-case basis. Now you've learned all about the defenses that are being routinely raised and how to go about attacking those. Hopefully you've been taking notes. We're going to give you a break. In the next segment, I'm going to talk about the role of your physician in your long-haul COVID claim and the post-COVID functional status test. Got it?
Have you been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.